to do with the principle of extraterritoriality. I was handling a human trafficking case in Tacloban, and then the perpetrator was an American citizen, and the victim is here in the Philippines, in Tacloban. And so the U.S. Department of State, through the U.S. Embassy here based, made me choose. I have an option whether to have him prosecuted in the U.S. because there is a law on commercial sex in U.S. If an American citizen is doing commercial sex in other countries, he can be prosecuted there in U.S. So he was prosecuted in U.S. instead of here. So it's similar to that. And it was successful. So I think we can also have this kind of extraterritoriality principle in our trafficking cases.
Madam Chair.
Yes,
We have subject, of course, the participation of our dear colleagues. We have sufficiently discussed it. So therefore, I move that we approve Article 2 with the amendment in paragraph 6, that it should be called AD ICT. So,
ICT.
yes, committed with so forth. And then we add also paragraph 7 as proposed.
By
We have to go forward already, not only on territoriality, but because we have so many Filipinos abroad, we like to protect them. And that is Section 5. And then also 6 will make also those responsible to us whether they are foreign or Filipinos. However, the situation is, a case will be filed, and in conspiracy, a foreigner is involved. Then, of course, he will not be arraigned because he's not here. But when he comes, then he will be reachable because you have these laws.
Yes.
So I move that we approve Article 2 with amendment in paragraph 6 to make, instead of computer, it should be ICT. And then we will have
Section
the
7.
article, paragraph 7. So move, Madam Chair.
There is a motion to approve Article 2 as amended.
Second, Chair.
Second, the motion has been seconded, and there being no objection, Article 2 is approved as amended. Article 3, crime, intent, and fault. Kindly go through the... Let me first recognize Representative, Attorney, Professor Jose Manuel Tadeo
Dean,
Chel.
former Dean.
Dean
Yes.
of LaSalle. Tadeo, Chel, I, Diokna of the Akbayan Party List. Thank you, sir, and we are expecting your valuable input, sir. Maybe you should share this. Thank you, sir. Okay, Article 3. Crime, intent, and fault.
Through their officers.
In the original, in the revised penal code, of course, what we have is the definition of acts and omissions, felonies. Then we have deceit and fault described there. In our last meeting, as I said earlier, we are removing the distinction between dolo and culpa in the new provision. Any comments on Article 3? Yes, Attorney Kirby.
UNODC supports the use of intent instead of malice.
Intent instead of malice. Last meeting also we said that we will use deceit. Yes, Attorney Man.
Yeah, I think we agreed on malice.
Malice.
Because deceit is the wrong translation po of...
Deceit is the wrong translation.
Dolo. May I...
Yes, go ahead.
Manifest some? Of course, good afternoon to the new honorable members, including my dean in the LSU, Dean Chel. I just taught last night po in the LSU. Now, Article 3 incorporates the no long crimen principle, and it has a definition of what a crime is. Okay, and here it says it's a crime, it's an act or omission punished in the code Previously, we just called this as a felony, right? And the definition in the revised penal code is an act or omission punished in a law, which I think is the correct definition of what a crime is. Because it will be an act or omission regardless of the law which punishes it. It will be considered as a crime. So we dispense with the felony. We now broadly state that all acts or omissions are crimes. So I suggest that under this code or other laws po, to also include those laws in the special penal laws which may not be incorporated if they are also considered as crimes po. Baka magkaroon ng confusion that they will not be considered as crimes
I
anymore.
remember, Attorney Dan, the reason is just to harmonize all of the laws. And I think in the last meeting we even said that it will be easier for law students because there was
Yes.
a problem learning the difference between felonies and offenses and crimes, right?
Yes.
So we are harmonizing everything and making all of them crimes, whether
Yes.
they are found in the revised penal code or in special
Special
laws.
laws. So I just request or suggest that we include our other laws.
Actually, Your
Because it
Honor,
just
right now,
says-
nobody's using felony.
Yes.
Even, I've been hearing even the debates here in Congress, nobody's using the
Correct.
felony. They're using the generic term crime.
Crime. Yes, that's correct.
And as discussed previously, I made the question, what about the strict liability crimes? Because in Article 3, it just talks about crimes committed with intent or with fault. In strict liability crimes like regulatory statutes, it will not be covered by this definition po. So I think we agreed that we should also incorporate a provision or phrase which will incorporate or justify why Congress is punishing strict liability crimes like anti-smoking. There's no dolo or negligence in smoking or this other regulatory
The mere
statutes
act.
po. Yeah.
Okay.
So, may I propose that we include, I think there's a suggestion before that we include a statement that Congress may also punish acts or omissions by reason of public policy. I think because it's by reason of to pursue general welfare or public policy that Congress may penalize certain acts, like in the Corporation Code, there's a penalty there. There's no need of culpa, negligence, or dolo.
Okay. So the proposal is to add a provision on this on the strict liability crimes like these regulatory crimes, anti-smoking, and we will have a statement there.
Batas Pambansa 22 is by reason of public policy. So
Yes.
Congress
Public
may
policy.
also enact laws punishing acts or omissions by reason of public policy po.
Madam Chair, if we will do that, we necessarily expand the coverage of our revised penal code. Now, our title already provides for relevant special penal laws. Now, as long as they're here, then we don't need to amend Article 3 because it will be defined and punished under this code. So those that are here would mean that they will be punished. Those that are not here continues under the special penal laws that are not included in our criminal code. So I think this is sufficient, Madam Chair, and it provides also the distinction between mala in se and mala prohibita, where there is intent in mala in se. Although we don't want to use that, but clearly Article 3 is still, there is still the intent requirement. In mala prohibita, the remaining laws. What will happen here, if they are included in this code, they will now become mala in se. I think we have chosen, I think the DOJ have chosen the specific penal laws that would need intent. The scienter will be the intent. And so that is what we will have here. Mala prohibita continues, the mere commission of crime, no need to prove intent, because that is just regulation, that is about policy. So I think this is okay, and we will not expand really. So I think the DOJ has, can you hear the DOJ? Because this comes from them, and they have really made it made it clearer, and even now with very much clarity. Can we, the DOJ, Madam Chair, this comes from the DOJ.
Yes,
I will
prosecutor.
answer the question of Congressman Cruz. The Criminal Code Committee of the Department of Justice decided to use the neutral word crime because we also envision that in the future the Congress will enact laws penalizing certain acts, so magiging parte rin yan ng criminal code. With respect to the manifestation of my friend here, Professor Calica, that instead of intent, it should be malice. But the present wordings of the revised penal code felony or a crime has three elements, one of which is intent, not malice. So intent is an element of felony or crime. If you're going to change that into malice, mukhang sasama ang tsura kasi ang malice is an exception. There are crimes na malice ang element. Libel, for example, or malicious mischief. That's why we maintain intent here, because in all Supreme Court decisions, intent is being used, not malice.
Yeah.
Thank you, Madam Chair.
Yes.
Madam Chair.
Yes.
Yes, on the issue of intent and malice, I'd like to hear why the representative from the UN is more in favor of intent. My understanding is that not all malicious acts are intentional, but not all intentional acts may be malicious. In fact, there are two specific crimes where we do have an additional requirement of malice, for example, in libel, and then we also have the distinction between actual and presumed malice when it comes to libel. So perhaps we could hear more from...
Thank you so much. Thank you so much, sir. So for us, the term malice carries a lot of common law baggage. So it can mean many things like implied malice, etc., in other jurisdictions. The second is, we have a centuries-old jurisprudence. We have centuries of 1 century filled with different case law on what malice means. Malice can mean intent, and sometimes the Supreme Court says it's ill will. So that can create some confusion. The other thing is we try to foresee a situation where, for instance, a public official awards a contract to his brother, and he can put up the defense that there's no ill will or malice, and that it was out of love or filial reasons, and that can be a defense. So when you say intent, it means by the mere reason that you did it, it was deliberately performed. I had resolved to do the certain thing. I had intent. And this also covers what was discussed earlier on about special laws. What about special laws? So, okay, smoking, of course you do not have to prove malice or ill intent, but the mere fact that you had resolved to commit that act, it was deliberate. And you had the intention to do it. So we can dispense with another provision on special laws. Yeah. That's it. Yeah.
Thank you, Attorney Tubayan. Attorney Harvey Bilang.
Yes, on a different point lang po with regard to second paragraph of Article 3 on fault, on the definition of fault. I would like to propose for the consideration of the body the removal of lack of foresight and lack of skill, coming from the perspective of, do we really want as a society to punish still just mere lack of skill, for example? So in place of that, I'd like to propose recklessness, imprudence, negligence, or willful blindness.
Willful what?
blindness.
Willful blindness. Can you define willful blindness?
You knew the risk, but you took on it anyway. Like you did the act anyway, regardless. Kasi di ba po sa criminal law we say that there's an evil mind, and the way to dispense with it is to say you don't know or you have no idea that it was evil in the first place. But if there are certain instances where you should have known, and because of your knowledge, you still took on the act. So that could be considered willful blindness. Or dispense it anyway because wala naman po tayong definition pa at the moment. Just addition of recklessness.
And remove lack of foresight or lack
And
of
lack of
skill.
Madam Chair, I would agree for the lack of skill. There are so many unskilled people in the Philippines. And so if we will put it lack of skill, then there will be many who will be charged under wrongful acts, under fault. So probably even lack of foresight, they can be really. So I would rather that we will, I don't know, but I am only for imprudence and negligence. Sufficient already, negligent ka, so prove mo negligent. Or you are imprudence. No?
Do we want to
Lack of foresight.
Do we want to use
do we need
reckless?
that to retain lack of foresight?
Because the prevailing doctrine now on how to determine recklessness or negligence is for the foreseeability test. That's the test adopted by the Supreme Court in all cases regarding Article 365. So if you include lack of foresight, that will be in accordance with the
But then when you say imprudence and negligence, already a Supreme Court said already includes lack of foresight. Necessarily kasi
It's a definition.
That's why you committed imprudence and you commit negligence because you have lack of foresight. So I think included them, but I don't know. But if my student says that we should continue with lack of foresight, I would agree. Now we remove lack of skill because medyo it provides a lot of our Filipinos would lack that skill. So I move, Madam Chair, with all the discussion.
Yes.
Article 3, the first sentence is, first paragraph is retained, and then the second paragraph, we will remove lack of skill.
Okay, there. Yes, Attorney Dan.
Yeah.
Will agree that an act or omission defined and punished in a law because, if we say under this code, then crimes would just be limited to this code. It will not cover acts or omissions defined in and punished in other laws. Precisely, this was the confusion in the definition of a felony before with the DOJ.
Professor Dan, we have also other laws, just like an ordinance of LGUs. They are also crimes. So, but these are not covered by the revised penal code or by this code because LGU has a separate power, has a power separate and distinct from the power of Congress to enact laws. So, if you include violation of ordinances, magiging subject siya ng Criminal Code of the Philippines. That's why, maingat ang revised penal code in Article 10 in using felony and offense because those are two different animals. Offense is a violation of special penal law. Just like in Article 116, quasi-recidivism, there can be no quasi-recidivism unless the second felony and second crime is an offense. So, may kunting distinction itong felony saka offense sa present revised penal code natin. Kaya pag dito, we will include those crimes punishable by special penal law, mukhang gugulo ata with respect to the application of the criminal code.
And in fact, there is a special name for as ordinances. It's infraction.
No, there's no law saying infraction of misdemeanor in the Philippines.
I think those offenses punishable under special laws. The laws punishing them have already imposed a designated penalties for them. So there will be no confusion if we will be retaining the crime is an act or omission defined under this code. So what are being attributed here are those crimes defined and finalized under the code of, specifically book 2. Yes.
Yes. Of course, I bow to the honorable Congress persons, but I'm just suggesting that a law, especially a penal law, should be clear and unambiguous. It should be clear. So, what do we now call those acts or omissions punished in other laws? We also call them crimes, because as of now, we now limited the definition of crimes to just those defined and punished in this code. So what do we call them?
We leave them, Madam Chair. The second paragraph is that the wrongful act here is the act that is really a crime under the revised penal code. So all others, they continue. They continue to be whatever you call them, offense, infraction, or what. But as long as wrongful acts, the phrase wrongful act, it means acts that are declared to be crimes under our revised penal code. So yun lang talaga. We cannot mention anymore special penal laws on others.
Just a last point, Madam
Yeah.
Chair,
Yes,
if I
Attorney
may,
Dan. Yes, go ahead.
Honorable Congressman.
Yes.
Okay. As I said, we just want the criminal code to be as clear as possible. That's just my intent. And we don't have any other names for crimes here in the Philippines. Before, we only have felonies and offenses. And offenses are those crimes defined and punished in other laws, other than the RPC. No? Now, I would like to clarify with my good friend, of course, that the crimes defined and punished in special or other laws are actually governed by the revised penal code. In the Article 9, proposed Article 9 of the DOJ proposal, it says here that this code shall not apply to crimes punishable under special laws. Okay, so it acknowledges that there are other crimes in other laws. No? So my understanding is that the criminal code is our principal criminal law in the Philippines.
Yeah.
No? That's my understanding. So it will govern all acts or omissions defined in other laws, okay? And that includes those defined and punished in special penal laws or other, or even in ordinances. So I'm just, it's just my humble submission that we should make it as clear as possible, the definition of what a crime is.
Yes.
Thank you.
Prosecutor.
Maybe not from the good professor, the exact wordings you would like to inject as far as this provision is concerned.
Instead of this code, by a law. The previous Article 3 of the RPC says felonies are acts or omissions punished by law. We just changed felonies to crime. A crime is defined and punished by a law, which incorporates the no long crimen principle. It's a basic principle in Philippine criminal law po.
Are we all agreeable to having one word, crime, for all laws punishing an act?
Yes, Madam Chair. Because precisely, Article 3, crimes are acts or omissions defined and punished under this code. So special laws, they continue. And the principle there is that they continue. They have their own penalties, they have their own requirements, and so forth. So therefore, this is to me already a very clear, like the second sentence is wrongful act. When you refer to the wrongful act, it is a crime, it is an act or omission defined and punished under this criminal code. So that is why it's quite, to me, it's quite clear. Now, on Article 9, precisely, it is suppletory. In fact, if the latter allow for supplementary application. So tuloy pa rin yung the code shall not apply. It's clear, it shall not apply to crimes punishable under special laws. There are some special laws, because our title says so, na pinasok na dito, which the DOJ have found that it has already reached a level of mala in se. That is the reason why. So
Chair
I call the
Rufus.
previous question, Madam Chair, to approve Article 2.
Chair Rufus, one last.
Yeah.
So did you mean to retain the term offenses for special penal laws?
No, it's all right, because now everything is already crime. Wala na yung mga offense na crime na. But it's clear that the crimes under special laws are special law crimes and already governed under Article 9. So as far as we are concerned here, Article 3, we have defined what a crime is, and a crime is also primarily a revised penal code, this code now. However, we still call them crimes also, applied to crimes, kasi maski ano yan, crime pa rin yan eh. Kaya lang, they're governed by special laws. That is Article 9. So to me, Article 3 is complete and can be very clear. Wrongful act here pertains to the commission of acts under this code.
What if we put crimes and act or omission defined and punished under this code and special penal laws? Because if you just put under this code, then it makes it appear that those punished under special penal laws are not crimes.
So we have provided that it will be also be the special laws continues. However, some special laws have already been incorporated here, and they become part already of the criminal code. So no need to say about penal laws special, because our title says there are relevant special penal laws already in the code. But those not in the code continue with their own lives. They will be prosecuted in accordance to the crime stated there. Now, whether that special law would say offense, infraction, it will still be a crime. Because we have already stated that in Article 9, it's still crime under special law. Yeah, okay. So,
Chair, I'll just
Your Honor,
recognize
please. City Prosecutor Sheila Marsaliganan Abadia of Danao City in Cebu po. I see the point of Professor Dan, but if we're going to change defined and punished under this code and other special laws, we have to remember that it follows the phrase is followed by committed with intent or with fault.
yeah.
And the special laws, some of them, they're
do
not
require.
yeah, they do not
Mostly-
require intent.
mostly,
so
yeah.
that's why I believe that
Malaprohibitae.
we should just retain this under this code. Prof. Thank you.
Thank you very much. Okay, we go back to the
I move to the
motion.
move for the previous question. My motion.
Yes,
Madam
there-
Chair, before we, if I may just
Yes,
revisit the difference between malice and intent. I'm not sure if there was already a previous consensus in the committee or the group on the use of the word malice. May I seek clarification on that?
I think Attorney Dan, can you answer
Yes,
Representative
I think
Diokno?
that's the agreement
In the
last
last-
meeting.
last
And
meeting.
in fact, there was a proposal to add additional praise, malice being a desire to cause harm or injury to another person po. Because, as mentioned earlier, this intent does not just, or malice does not just involve deliberateness or voluntariness, as the Honorable Congressman mentioned earlier, because a crime consists of three elements. There's freedom, which is deliberateness or voluntariness in the act. And when we say committed with deliberate intent, just goes into the freedom to commit the act or omission. But it does not go to the intent. It's actually committing the act or incurring the omission with a desire po to cause harm or injury to another person. That is what the Supreme Court said is the definition of malice po. The desire to cause harm or injury to another person. So we suggested that it be included in the paragraph, Article 3 rather. Thank you po.
Congressman Diokno, in the last meeting, we agreed to remove deceit and then to use malice, but now we have this new version of the DOJ bill, and thus we are again discussing this portion because here they used intent in their proposed bill.
I would personally, Madam Chair, if I may, be more inclined to continue with the use of the word intent because that is, we have a body of jurisprudence already that defines that. If we were to use malice, may iba po yung interpretation. And again, that will probably give rise to more litigation rather than less. We don't want to burden the court, the Supreme Court especially, with more issues.
Thank you, Representative Joke. And of course, like you also said earlier, not all malicious acts are intentional. Not unintentional are malicious, but all malicious acts are intentional. Okay, going back, we have a motion of Representative Chair Rufus. Do I hear a second?
Second, Chair.
Okay, so we approve there being a motion which was duly seconded, and without any objection, we have approved Article 3 as amended without the phrase or lack of skill. We proceed with Article 4 on criminal liability.
I'm sorry, Madam Chair.
Yes, go ahead.
I just missed that portion. But would the good gentleman, Congressman Rufus, be willing to amend the motion to adopt the word intent rather than malice?
Yeah, it's intent. I have moved that because intent is now very clear. An act has intent if it is deliberately performed. So deliberate. So he knows what he's doing. He's going to do it, and so that is intent, not any more malice. Thank you. Yeah.
Okay, going to Article 4, criminal liability. When we discussed this last time, we had the discussion on impossible crimes. Yes. Okay po. Huwag po kayong pag-away na.
Watching people there. They will not be pro-China.
Okay. So there, excuse me, there's a big change from the wording of Article 4 in the revised penal code and the wording in the earlier House bills that we filed. So criminal liability shall be incurred by any person committing a crime. Criminal liability shall also be incurred by committing an intentional crime, although the wrongful act be different from that which was intended, or performing an act which would constitute a grave or less grave crime, were it not for the inherent impossibility of its accomplishment or on account of employment of inadequate or ineffectual means. Can I get your comments on this, especially those from our practicing prosecutors, since you know this very well? Comments? Yes, prosecutor.
I think this is just a reiteration of the original text of Article 4, except iba yung wordings, because we use impossible crime. The present wordings of Article 4 are presented by way of enumeration. The first is by committing a felony, even if the crime intended was a different one, and impossible crime. So there's no substantial difference between the original and the proposed draft of Article 4, except maybe in the definition of impossible crime, under this draft, we will not include light felony or light crime, or those light light crimes, because we made it clear that impossible crimes only exist if it is a grave or less grave crime. That's the improvement or the amendment.
Okay. Any more
Yes,
comments?
Madam Chair.
Yes.
A point of inquiry from Professor Nohara with regards to the new definition of impossible crime that criminal liability shall be incurred by performing act which would constitute a grave or less grave crime, were it not for the inherent impossibility of its accomplishment or on account of unemployment of inadequate or effectual means. To my recollection, an impossible crime is a crime of last resort. For example of this, for example, A saw his bitter rival B is sleeping inside the house which was locked. So he went inside, and at that point in time, he pumped 6 bullets from his snub nose, not knowing that A was already dead. So, applying the principle of impossible crime, because we can no longer charge him with murder because of the inherent impossibility, because you cannot kill a person who's already dead. So, the most that we can charge him is trespass to dwelling. So, with this provision that it only involves grave or less grave felonies, so he will go scot-free. Is that my understanding, Professor Nahoro?
Yes.
As you can read from the draft, we already excluded light crime or those crimes punishable by arresto minor. So the reason for the exclusion is that para bang napakaliit na yun para pag bibigyan mo pa ng attention. So we'll just concentrate on more yung heavier crimes with heavier penalties.
I submit, Your Honors.
Okay. Any more comments on, excuse me, on Article 4? Yes, Professor Dan.
May the DOJ consider there's in the impossible crime before, as mentioned, there's no crime actually committed, no? And in the previous definition of impossible crime, it applies only to crimes against persons or property. So this somewhat expands the definition by we now have an impossible crime of kidnapping or impossible crime of treason or impossible crime of possible, that will be possible, no? But my query really is on account of employment or inadequate or ineffectual means, Madam Chair, because an example of inadequate is it's really poison, but the amount is inadequate to kill. Wouldn't that constitute already attempted murder? So this the use of the term inadequate really might be confusing, and may I suggest that it be removed, because if it is ineffectual, then the crime really cannot be produced. But if it is inadequate, the crime can actually be produced, but the amount of poison used was just inadequate. If I may do so, but I'm not in the prosecution service, I will charge this person instead with attempted murder, not with an impossible crime.
Yes,
thank you.
Madam Chair.
Yes,
Yes,
Prosecutor.
I agree with Professor Calika. On that particular example, the perpetrator shall be charged with an attempted murder because of it. Will be different if the perpetrator mistook that the poison and he placed sugar on it. That will constitute impossible crime. And to my recollection, the crime intended will not be committed, but the accused, if there is a violation of the revised penal code, he should be charged with that particular provision in the revised penal code. But if there is a violation of special law, then he will go scot-free.
Should we add that collateral, sir? That
My suggestion, Madam Chair, is just to remove the word inadequate.
Ineffectual.
Inadequate, yes. Retain
Retain
ineffectual
ineffectual.
po, Madam Chair.
Yes, sir.
Because if it is ineffectual, it's really impossible from being accomplished. But inadequate, it can be accomplished, but it was just, the offender just used inadequate means.
Your Honor, would that be, sir, what is it not that what's being penalized here is the propensity of the person to commit the crime
Yes, yes.
and not the result? Why the need to remove it?
Yes, precisely. I will charge that if I'm a prosecutor po, with attempted murder, not with impossible crime. So,
Yes.
inadequate really is not a proper word to describe impossible crime po. That's what I'm saying po.
I agree po with Professor Kalika that maybe we can just remove the inadequate, because if it's inadequate, there is still a crime. But when
There is
it's
still a
ineffectual, there's no crime. Thank you.
So the proposal is to remove the word inadequate. Okay, are we agreeable to that amendment? It seems yes. Can I
Madam Chair,
solicit a
that
motion?
being that part of the discussion being done, I move to adopt Article 4 as proposed, with the deletion of the word ineffectual. Ineffectual means. So,
Second, Madam Chair.
Okay, we have a motion to approve Article 4 as amended. And this motion has been seconded, and without any objection, Article 4 is now Article 4 of House Bill number 7142 and 7206 is now approved. Yes, prosecutor.
Can we be clarified as to which word was used? Is it ineffectual or
Inadequate.
Inadequate.
as proposed by Congressman Colliantes?
Inadequate proposal means
I apologize, Chair. May I take back my motion and instead replace the deletion of the words ineffectual means and retain that, and instead delete the word inadequate.
Okay, thank you very much. So there is a motion which is also duly seconded. We now approve Article 4 on criminal liability as amended. Article 5 on consummated, frustrated, and attempted crimes. Okay. Consummated, frustrated, and attempted crimes are punishable. A crime is consummated when all the elements necessary for its execution and accomplishment are present. It is frustrated when the offender performs all the acts of execution which would produce the crime as a consequence, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. There is an attempt when the offender commences the commission of a crime directly by overt acts and does not perform all acts of execution which would produce the crime by reason of some cause or accident other than the offender's own spontaneous desistance. Any comments? I think it is very similar to
But
the
it's a
original
matter
one.
of just a form, Madam Chair, because
Yes, Professor.
the first paragraph of Article 5 establishes the rule that attempted, frustrated, and consummated crimes are punishable. And Article 6 provides for an exception po, except when the crime is a light crime, it is punished only if it is consummated. So just a matter of form, I suggest that Article 6 be incorporated in the first paragraph of Article 5 po, and then the definition may now be the Article 6 po, definition of the three stages, if the DOJ will agree to that suggestion po.
Attorney Dan, again, your proposal is to move light crimes, the Article 6 on light
Article
crimes.
6. Because the
to
first paragraph,
Paragraph 1 of Article 5.
yes. Because Article 6 just provides an exception to the first paragraph in Article 5 po.
Okay.
Madam Chair,
Yes.
we have no objection on the suggestion of Attorney Dan Calicut.
Thanks, sir. Okay. So the proposal is to put the definition of light crimes under or after the first paragraph of Article 5. What do we put under Article 6, sir?
Definition po, Madam Chair.
Definition of
The consummated crime, frustrated crime, and attempted crime be
Okay.
transferred to Article
Okay.
6 po.
Yes, for better wording. Okay. So the definition of a crime is consummated onwards will be Article 6, whereas light crimes will go to Article 5. Just for
Madam Chair,
Yes,
what will be
ma'am.
the suggestion of Professor Kalika as to the title of Article 5 if the definition of the consummated, frustrated, and attempted will be transferred to Article 6?
acts which are punishable.
Pwedeng punishable crimes or
Punishable acts.
punishable acts or omissions or stages which are punishable. And then the title for Article 6 would be Consummated, Frustrated, and Attempted Crimes.
Professor,
Okay. In our last meeting, I remember that we said that we will put 3 stages. Excuse me.
Madam Chair, Madam
Yes,
Chair,
ma'am.
may I be recognized?
Yes.
Thank
Go
you.
ahead.
If I may, maybe we can put in Article 5, crimes punishable,
Crimes
and then
punishable.
the Article 6 will be consummated, frustrated, and attempted crimes.
Yes. I accept that. Yeah. Okay. 5 and 6.
Madam Chair, may I move to accept the proposal of the good city prosecutor and of course Attorney Dan in moving Article 6 to Article 5 and 5 to 6, wherein the proposed Article 6 will now define consummated, frustrated, and attempted, and Article 5 being which crimes are punishable. So, Madam Chair.
Okay, there is a motion to move Article 6 to Article 5 after the first sentence, and from the definition of consummated crime, frustrated, and attempted to Article 6, and the motion has been seconded. So we approve Articles 5 and 6. Next. Subject to style, of course. Okay. Next is Article 8. Of course, we will renumber this later on, but they put Article 8 on conspiracy and proposal to commit crime here. Conspiracy and proposal to commit crime are punishable only in the cases in which the law specially provides a penalty therefor. conspiracy exists when two or more persons come to an agreement concerning the commission of a crime and decide to commit it. There is proposal when the person has decided to commit a crime, proposes its execution to some other person or persons. So we use the word crime. Is everyone agreeable to that? Yes, I would think so.
Madam Chair, I move to adopt Article 8 of House Bill number 7142.
Okay,
House
there's a
Bill
motion.
7206.
There's a
Madam
motion to adopt Article 8, and the motion has been seconded, and with there being no objection, we adopt and approve Article 8. Now, next is Article 7. Okay, we will renumber that again. Is it correct, DOJ, that we're just changing the terms here? Crimes. Grave crimes are those to which the law attaches the afflictive punishment or penalties which in any of their periods are afflictive in accordance with Article 24 of this code. Less grave crimes are those which the law punishes with penalties which in their maximum period are correctional in accordance with Article 24 of this code. Light crimes are those infractions of law for the commission of which a penalty of arresto menor or a fine not exceeding 40,000 pesos or both is provided. Any comments? Yes,
we just
Prosecutor
eliminated the death penalty from the enumeration under Article 24 of the proposed code, since Republic Act, it was certain Republic Act already suspended the application of the death penalty. So to be more consistent with that Republic Act and the prevailing jurisprudence as enunciated by the Supreme Court, the afflictive there is no more capital penalty under this proposed draft, Madam Chair.
Okay. Are we okay? We're okay. Yes, Professor Dan.
Madam Chair, may we consider there's a ongoing conflict between the definition of crimes and the classification of fine as afflictive, correctional, and light. This is in Article 26. This is actually a very long conflict already, Madam Chair. So it says here that light crimes are those infractions of law for the commission of which a penalty of arresto menor or a fine not exceeding 40,000 pesos or both is provided in Article 8. And so if the amount is 40,000 pesos, okay, in Article 26, however, it says here that a light penalty, a fine is considered as a light penalty if it be less than 40,000 pesos. So it should be 39,999. But here, 40,000 in proposed Article 7, not exceeding. So there's a conflict. So
yes, tama.
Or a fine
Let us change that.
less than, just to harmonize with Article 26 for Madam
Yes.
Chair.
What would be your suggestions? Suggestion? Or a fine less than 40,000.
Not exceeding what siya. It says
Page 25. And a light penalty if it be less than 40,000 pesos. So dapat light crime. less than. So it should to harmonize it with Article 26, it should be, or a fine less than 40,000 pesos. Agree? Yes, to be consistent. Okay.
Tama. Yes,
Buti na lang nag-attend kayo, may magmo-motion.
Hindi ka ito
Noong una pa, isa-isa na mawala. Okay na. Yes, sir.
Okay,
Less than.
Madam Chair, I move that we adopt Article 7 of House Bill 7142 and House Bill 72406 with the correction of the words, with the deletion of the words fine not exceeding to be replaced with less than.
Thank you. We have a motion to approve and adopt Article 7 as reworded. It has been... Yes, ma'am.
Sorry. Before the seconding of the motion, we just want to address the seemingly just a formal correction on the first paragraph because the afflictive is mentioned twice, Madam Chair. Attaches the afflictive punishment or penalties which in any of their periods
Okay.
are afflictive.
Yeah.
Thank you, Madam
Okay,
Chair.
we will revise. Yes. So our motion has been seconded. We approve Article 7 as reworded, subject to style. Article 9, suppletory application of the provisions of this code. This code shall not apply to crimes punishable under special laws unless the latter allow for suppletory application. Yes, Attorney Harvey, bilang.
Suggestion to adopt instead the version of HB numbers 4374 and 5446. I'll explain. I think it's better to provide suppletory application as a general rule and then for Congress to just provide exceptions if it intends not to apply the code to special penal laws because we don't want an impression that special penal laws are independent kingdoms. Or, what's involved here is the punishment powers of the state, so I think this should be the bedrock of that.
I understand. Yes. Yes. I agree. Yes. Do you agree? I agree.
Yes, because with this proposed provision, conspiracy will not be applicable anymore to special penal laws, but it's often used in prosecuting offenders under special penal laws po. So, I think the reverse might be more responsive because the special penal law may provide that the provisions of the RPC will not apply. Okay. Thank you po.
Under our earlier House bills, what is stated is this code shall be supplementary to special penal laws unless the latter should specially provide the contrary. Should it be suppletorily? Shall be suppletory to special penal laws?
Yes, that's what the Supreme Court...
Suppletory is the word, correct?
Supplementary or
Not
supplementary. The Supreme
What
Court
is the
has...
better term? Suppletory, supplementary?
Supplementary po.
Nalala ko, tinatanong din yan sa exam, diba? Okay. Okay. Yes.
Madam Chair,
Thank you.
I move that we...
Hold on. I'm sorry. Yes, ma'am.
I would just like to add po regarding the wording of the special penal laws because that's the proposal po, correct? I would like to propose for the body to consider what if we use special laws instead because the title of our code is amending RPC, relevant special penal laws, and also special laws with penal provisions so that the special laws with penal provisions would also be copied.
So the proposal is the code shall be suppletory to special laws unless the latter should specially provide the contrary.
Madam Chair,
I move that we adopt or change the wording of Article 9 to be read as this code shall apply suppletory.
Shall be suppletory.
Shall be suppletory
Special laws.
special laws unless the latter should specifically provide the contrary.
Okay.
So moved, Madam Chair.
Just a comment, Madam Chair, as to style. Maybe
Okay.
instead of deleting penal, maybe we can just replace special with other, so that it would read other laws. Because,
Definition.
yeah, there's no definition of what a special, because we removed penal, then special law will just be any other law as well. Oh, but we
Other laws.
we
Okay,
delete,
okay.
we're going to
Other
delete
laws.
penal.
Okay, it's other laws. Okay, there is a motion.
Subject to style ulit.
Subject to, there is a motion which has been duly seconded. We approve Article 9 as Article 9, and Article 9 will be read as this code shall be suppletory to other laws unless the latter should specially provide the contrary. Okay.
Second.
Subject to style. Okay, let's proceed. Chapter 2, justifying circumstances and circumstances which exempt from criminal liability. Article 10, justifying circumstances. Yes, sir.
Point, before we proceed to the other topic, want to make an inquiry. Considering that we have been discussing one of the classes of penalties afflictive, and if we will examine the proposed code, the most serious penalty classified as afflictive is reclusion perpetua. I would like to make an inquiry. Are we already totally closing the door for the reimposition of the death penalty in some exceptional cases? May we know from the honorable members of the committee or our presiding officers, Madam Chair, if we are already totally closing the door for the reimposition of the death penalty in some exceptional cases. Because what is proposed in the code, the most serious penalty is reclusion perpetua.
Your Honor, the terminology, it was removed on the draft, but it does not foreclose anything. The point is that even it is a death penalty, the penalty is still under the category of afflictive. It covers death penalty.
Madam Chair, what I'm trying to imply is whether this committee is inclined to reimpose death penalty in some exceptional cases. Because later on we will be going to that discussion. Because we have already been defining the penalty for less serious, grave felonies, less grave felonies, and light felonies.
I
That
believe
is only my
that
proposal,
okay.
Madam Chair.
We acknowledge your proposal, sir, but that is not the policy direction of
Thank you.
the House of Representatives right now. Okay.
Thank you, Madam Chair.
Thank you very much. Well, we are about to enter Chapter 2, but if it is all right with the body, I would like to stop at this point. Yes. We apologize, but our brains are fried from the impeachment this morning, and we've been tackling the impeachment for the past several days, and tomorrow we still have another day of impeachment.
Madam
Yes,
Chair.
ma'am.
before we adjourn, and by the way, we appreciate your announcement because some of us also have a flight to catch, and we were supposed to leave at about 4 p.m. Thank you very much
So
for that,
that's
Mr. Chair.
perfect.
But before that, Madam Chair, I would like to extend the message of Yusek Raul Vasquez.
Yes.
He says that he really wants to be here, except that he had to undergo dialysis and medical
Yes.
procedure.
Of
So
course,
just
he
so
wants
you
to be
know.
here because I'm his favorite partner in our law office. So again, apologies that we have to cut to now. Thank you very much for attending. We expect your attendance on February 18 and 24 at 10 o'clock in the morning, assuming there's no impeachment there. Wala pang someone please.
Madam Chair, favorite motion, move to
Favorite-
suspend.
Okay, there is a duly seconded motion to suspend. Thank you very much, everyone. This meeting is suspended. Thank you.